license and registration. Now,
before I hand you anything, what's the legal reason for this stop?
Ask the questions. You answer. Step out of the car.
Step out for what? You haven't articulated reasonable suspicion?
Don't get smart. People like you make this worse.
People like me.
Define that. Badge number and call your supervisor. You're free to go.
Name and badge on the record.
It was 2:15 p.m. on a quiet, tree-lined street in Pasadena, California. The Southern California sun was beating down on the asphalt of the residential neighborhood. And in the next 14 minutes, a routine traffic stop would transform into a constitutional law masterclass that would end one officer's career, cost the city $365,000, and become required viewing at police academies across the nation. The man behind the wheel wasn't just any driver. I am Dr. Marcus Sterling, one of the most respected constitutional scholars in the country, and I had just been pulled over for what I immediately recognized as absolutely nothing. Before we dive deeper, where are you watching from? Drop your location in the comments below. And if you believe people should know their constitutional rights, smash that subscribe button. This story is about to get intense, and you won't want to miss a single moment. I was 45 years old, and at the peak of my profession. I had graduated from Yale Law School, clerked for a Supreme Court justice, and had been teaching constitutional law at UCLA for 15 years. My specialty was the Fourth Amendment, the protection against unreasonable searches and seizures. I had published 3 books on the subject, testified before the House Judiciary Committee half a dozen times, and trained hundreds of lawyers who now worked across the country defending civil liberties. But here's what made me particularly formidable in a situation like this. I didn't just know the theory of constitutional law. I knew every major Supreme Court case from the last half-century. I could recite Holdings' dissents and footnotes from memory. My students joked that I had the entire United States reports embedded in my brain. When I taught my Fourth Amendment seminar, I would act out traffic stops and searches, playing both the officer and the citizen, demonstrating exactly where the line between legal and illegal fell. I had spent the last decade also doing something else, training public defenders and civil rights lawyers on how to challenge unlawful stops. I ran a clinic at UCLA where law students represented clients in cases involving police misconduct. I had personally handled 19 cases involving constitutional violations by law enforcement. I had won 16 of them. That Tuesday afternoon, I was driving home from campus. I had just finished teaching my constitutional criminal procedure class. The discussion that day had been about pretextual stops when police use minor traffic violations as an excuse to stop someone they want to investigate for other reasons. It was a topic I felt strongly about because pretextual stops were often a cover for racial profiling. I was driving my gray Toyota Camry. The car was 5 years old, but pristine. My registration was current. My inspection sticker was valid. Both tail lights worked. My tags were clearly visible. I was driving exactly 33 miles per hour. In a 30 miles per hour zone, 3 miles over, but well within the margin of error that officers typically allow. I was simply driving home through a quiet neighborhood, thinking about my lecture notes for the next day. Then I saw the flashing lights in my rearview mirror. My first thought was confusion. I mentally reviewed the last several minutes of driving. No stop signs run, no traffic signals violated, no erratic maneuvers, no speeding beyond that minor 3 miles per hour over the limit. I genuinely had no idea why I was being stopped. I pulled over carefully, put the car in park, turned off the engine, and placed both hands on the steering wheel at 10 and 2. I also did something most people don't think to do. I activated the voice recorder on my phone, which was mounted on my dashboard. The recorder was already running when Officer Derek Cole approached my window. Cole was 34 years old, with 9 years on the Pasadena Police Department. He had a decent record with no major disciplinary incidents, though he had received 4 citizen complaints in the past 3 years, all dismissed as unfounded. He was known among his colleagues as someone who made a lot of traffic stops. His ticket numbers were always high, which his supervisors saw as a sign of proactive policing. What those statistics didn't show was the pattern. Cole stopped black drivers at a rate nearly 5 times higher than white drivers in his patrol area. When he stopped white drivers, he typically issued warnings. When he stopped black drivers, he typically issued citations. And when he stopped black men driving alone, he often became what his colleagues privately called assertive. Cole walked up to my window with his hand resting on his service weapon, not drawing it, just resting there. It was a posture designed to intimidate. As a black man in America, I noticed it immediately. I greeted him politely and asked why I had been stopped before providing any documents. It was the right question to ask. Under the law, drivers have the right to know why they're being detained, but many officers don't like being asked. Cole responded with the classic deflection. He told me that he asked the questions and I answered them. Then he demanded my license and registration. But I wasn't going to let it go that easily. I asked again this time, explaining that under the law, he needed reasonable suspicion to stop me. I asked him to tell me what that suspicion was. My tone was professional calm, but absolutely firm. Cole felt something he didn't feel, often uncertainty. Most people just handed over their documents. They didn't ask about reasonable suspicion. They didn't use legal terminology. He asked if I was a lawyer trying to figure out who he was dealing with. When I identified myself as a constitutional law professor, Cole's confidence wavered for a moment, but he pushed forward, dismissing my expertise. He told me he didn't care what I was, and that I had been driving suspiciously. He demanded my license and registration again, but I immediately challenged that. I pointed out that suspiciously wasn't a traffic violation and didn't meet the legal standard for a stop. I asked for the specific statute I had violated. Type, "He knows his rights" in the comments if you think I had him beat from the start. Cole's jaw tightened. He wasn't used to this level of pushback. He told me I was being argumentative. I corrected him. I said I was being precise. There was a difference. Then Cole made his first major mistake. He ordered me to step out of the vehicle. It was an escalation meant to reassert his authority. But I knew the law on this too. I asked on what legal grounds he was ordering me out of the car. The Supreme Court had ruled in Pennsylvania versus Mims that officers could order drivers out of vehicles during traffic stops for officer safety. But that was only if the stop itself was legal. If the initial stop was unlawful, everything that followed was fruit of the poisonous tree. I was challenging the foundation of the entire encounter. If Cole couldn't justify the stop, he couldn't justify any subsequent orders. Cole tried to shut down the conversation. He said he wasn't going to argue on the side of the road. My response was brilliant, if I do say so myself. I told him to call his supervisor because what he was doing was going to cost him his badge. It was a statement of fact, not a threat, and Cole didn't like it one bit. He asked me if I was refusing a lawful order. I said I was questioning whether the order was lawful, given that the underlying stop appeared to be unlawful. I said if he had reasonable suspicion or probable cause, he should articulate it. Otherwise, I was being detained without legal justification. Cole leaned closer to the window. His voice took on an edge. He said I was acting like I knew more about police work than he did. I told him I certainly knew more about constitutional law. Then Cole said something that would come back to haunt him. He told me that people like you should be more cooperative, that guys with my attitude often found themselves in worse situations, that I was making this much harder than it needed to be. I caught every word. I asked Cole directly what he meant by people like you. What situation was he referring to? Me being alone. Me being a black man. What exactly? Cole tried to backtrack. He said he meant people who were being stopped by police, but the implication had been clear. The recording had captured it all. The edge in his voice, the coded language, the attempt at intimidation. I told Cole I was a law professor at UCLA. I specialized in constitutional law and the Fourth Amendment. I trained lawyers and testified before Congress on police accountability. I told him I knew exactly what my rights were, exactly what his authority was, and exactly where the line between them fell, and he had crossed that line the moment he initiated this stop without reasonable suspicion. Cole's confidence evaporated. He stood there for a long moment, saying nothing. The silence stretched out for 11 full seconds, an eternity in a confrontation like this. Finally, Cole stepped back and told me I was free to go, just like that. No ticket, no warning, no explanation, just, you're free to go. But I wasn't done. I asked for his name and badge number. Cole hesitated, then provided them. Officer Derek Cole, badge 4921, Pasadena Police Department. I thanked him and told him I would be filing a formal complaint with his department's Internal Affairs Division. I would also be requesting all dash camera and body camera footage from this stop, and I would be contacting the ACLU about a potential civil rights lawsuit. Cole said nothing. He just walked back to his patrol car. The entire encounter had lasted 14 minutes and 23 seconds. I drove away and immediately called my colleague at UCLA who ran the civil rights clinic. By the time I got home, we had already started drafting the complaint. By that evening, I had contacted 3 separate organizations, the ACLU of Southern California, the NAACP Legal Defense Fund, and the Lawyers Committee for Civil Rights Under Law. All 3 were interested in taking the case. I also did something else. I posted about the encounter on my Twitter account. I had 95,000 followers, mostly lawyers, law professors, judges, civil rights advocates, and journalists. I described what had happened in a detailed thread, explaining each constitutional issue as it arose during the stop. I didn't post the audio recording publicly, not yet. I wanted to go through proper channels first, but I made it clear that I had a complete recording and that it documented every violation. The response was immediate. Legal scholars weighed in. Civil rights organizations offered support. Journalists requested interviews. Within 24 hours, the story had been picked up by local news outlets. Within 48 hours, national legal publications were covering it. The Pasadena Police Department issued a statement saying they took all complaints seriously and would investigate, but this wasn't a complaint they could quietly dismiss. The complainant was a UCLA law professor who knew the system inside and out. The incident was recorded and the entire legal community was watching. Have you ever felt like a traffic stop was based on your appearance rather than your driving? Let us know in the comments. The department's Internal Affairs Division assigned the case to Lieutenant Maria Rodriguez. Maria had been investigating officer misconduct for 8 years. She was thorough, fair, and not afraid to hold officers accountable when evidence warranted it. When she saw who the complainant was and read the detailed statement I had provided, she knew this case was going to be significant. Maria pulled all the footage from Cole's dash camera and body camera. The body camera confirmed everything I had described. Cole approaching with his hand on his weapon. The vague explanations for the stop, the escalation, when I asked questions, the implied threats about people like me, the complete inability to articulate any traffic violation. Maria also pulled records of all of Cole's traffic stops for the previous 3 years. She wanted to see if there was a pattern. What she found was damning. Cole had made 912 traffic stops in 3 years. Black drivers accounted for 68% of those stops, even though black residents made up only 10% of Pasadena's population. When Maria broke it down further, black men driving alone accounted for 41% of Cole's stops, a proportion wildly out of line with their representation in the population. Maria looked at the outcomes of these stops. White drivers received warnings 72% of the time. Black drivers received warnings only 18% of the time. The citation rates were almost perfectly inverted. She looked at the reasons for the stops. Many were vague, suspicious driving behavior. Vehicle appeared to be weaving. Driver looked lost. Very few cited specific traffic violations with clear probable cause. Maria interviewed Cole 2 weeks after the incident. He came with his union representative and a lawyer. He was no longer confident. He was defensive. Maria asked him why he pulled me over. Cole said my driving seemed erratic. Maria asked him to describe the erratic behavior. Cole couldn't provide specifics. He said I was driving slowly and seemed unfamiliar with the area. Maria pointed out that driving slowly wasn't illegal and that appearing unfamiliar with an area wasn't a traffic violation. She asked what specific law I had broken. Cole admitted he couldn't identify a specific violation. He said it was more of a gut feeling that something was off. Maria asked if Cole had run my license plate before initiating the stop. He had. It came back clean, current registration, no warrants, no flags. So even before the stop, Cole knew there was no criminal activity associated with the vehicle. Then, Maria asked about the comment regarding people like you. Cole claimed he meant people who were being stopped by police. Maria asked why he specifically used that phrasing rather than citizens or drivers. Cole didn't have a good answer. Maria showed Cole the statistical analysis of his stops, the disproportionate targeting of black drivers, the differential treatment in outcomes. She asked him to explain the pattern. Cole said he patrolled areas with higher crime rates, which explained why he stopped more black drivers. Maria pulled up a map showing Cole's patrol zones and the locations of his stops. Many of his stops were in low-crime residential neighborhoods, including the area where he stopped me. The crime rate explanation didn't hold up. The interview lasted 2 hours. By the end, Cole knew he was facing serious consequences. Maria's investigation report was 63 pages long. It concluded that Cole had made an unlawful traffic stop without reasonable suspicion or probable cause. It found that Cole engaged in a pattern of discriminatory policing targeting black drivers at rates far exceeding their representation in the population. It found that Cole had attempted to intimidate a citizen for asserting his constitutional rights. The report recommended termination. The Pasadena Police Department's command staff reviewed the report. They consulted with the city attorney's office. The city attorney told them bluntly that if this case went to trial, they would lose badly. A UCLA law professor with a perfect recording clear evidence of constitutional violations and statistical evidence of racial profiling, a jury would award significant damages. 3 weeks after Maria completed her investigation, the Pasadena Police Department held a disciplinary hearing. Cole attended with his lawyer and union representative. They argued that the stop had been based on legitimate concerns about my driving behavior and that any statistical anomalies were the result of Cole's patrol assignments, not bias. The hearing board wasn't convinced. The evidence was too clear. The pattern was too obvious. The violation of my rights was too blatant. Officer Derek Cole was terminated from the Pasadena Police Department for cause. The termination letter cited multiple violations, conducting an unlawful traffic stop, engaging in racially discriminatory policing, attempting to intimidate a citizen, and failing to meet the professional standards expected of the department. Cole appealed the termination. His appeal was denied. He filed a grievance through his union. The grievance was denied. He threatened to sue the department for wrongful termination. His lawyer reviewed the evidence and advised him not to pursue it. The case against him was airtight. But the department's problems weren't over. My lawyers had filed a federal civil rights lawsuit. The lawsuit named Cole individually and the city of Pasadena. It alleged violation of the Fourth Amendment, racial discrimination under the Equal Protection Clause of the 14th Amendment, and intentional infliction of emotional distress. The city tried to fight the case initially. They argued that even if Cole's actions were inappropriate, they shouldn't be held liable because they had proper policies and training in place. But my legal team showed that the department had received multiple complaints about Cole's stop patterns and had dismissed them all without proper investigation. The city had failed to supervise and had turned a blind eye to discriminatory policing. Do you think police departments do enough to identify and stop officers with patterns of discrimination? Drop your thoughts below. The case never went to trial. 10 months after the incident, the city settled. The settlement included several components. I received $210,000 in damages for the violation of my constitutional rights and the emotional distress of being unlawfully stopped and threatened by a police officer. I also received $155,000 to cover my legal fees, even though much of my legal representation had been provided pro bono by civil rights organizations. More importantly, the settlement required the city of Pasadena to implement comprehensive reforms. Within 1 year, the police department had to implement an early warning system that flagged officers whose stop patterns showed statistical anomalies suggesting bias. Officers flagged by the system would receive mandatory retraining and increased supervision. The department had to revise its training on constitutional stops to include specific instruction on articulating reasonable suspicion, avoiding pretextual stops, and recognizing implicit bias. All officers would receive this training annually, not just during the academy. The department also had to implement a new system for investigating citizen complaints. Complaints alleging discrimination or constitutional violations would be investigated by an independent civilian review board, not just internal affairs. Finally, the department agreed to publicly report data on traffic stops quarterly, including demographic breakdowns of who was stopped, the stated reasons for stops, and the outcomes. The data would be posted online for public review. I donated my entire settlement to 3 organizations: the UCLA Civil Rights Clinic, where I taught the ACLU of Southern California, and a local organization that provided legal assistance to low-income residents facing police misconduct. I didn't need the money. I had wanted accountability and change. The settlement delivered both. The audio recording of the traffic stop was eventually released as part of the court proceedings. News outlets obtained it and published it online. Within a week, it had been listened to or viewed more than 8 million times. Legal commentators dissected it. Police training experts used it as an example of what not to do. Civil rights organizations used it in community education programs about knowing your rights. Law schools across the country started using the recording in constitutional law classes. Students would listen to the audio and identify each legal issue as it arose. Where did the stop become unlawful? When did the officer violate the Fourth Amendment? How did Dr. Sterling assert his rights effectively? What should the officer have done differently? The recording became known in legal education circles as the Sterling Stop. It was considered a perfect real-world example of Fourth Amendment principles in action. Derek Cole never worked in law enforcement again. His termination for cause made it nearly impossible to get hired by another police department. He tried applying to several departments in other states, but his disciplinary record came up immediately in background checks. He eventually found work as a security supervisor at a private company, making about 60% of what he had earned as a police officer. People who knew him said he remained bitter about what had happened. He felt he had been made a scapegoat for systemic issues that existed throughout law enforcement. He never publicly acknowledged that his actions had been wrong or that his pattern of stops had been discriminatory. I continued teaching at UCLA. The incident made me an even more sought-after expert on police accountability and constitutional rights. I was invited to consult with police departments across the country on reforming their stop policies. I testified before Congress twice more about the need for federal standards on traffic stops and data collection. I also expanded my civil rights clinic at UCLA to focus specifically on unlawful traffic stops. The clinic took on dozens of cases each year, representing people who had been stopped without legal justification. Many of these clients were people who didn't have my knowledge or resources, but who had experienced the same violations I had. The Pasadena Police Department implemented all the required reforms on schedule. The early warning system flagged 6 officers in its first year of operation, all of whom showed stop patterns with significant demographic disparities. Those officers received retraining and closer supervision. 2 of them eventually left the department voluntarily. The quarterly data report showed gradual improvement in stop patterns. Racial disparities narrowed, though they didn't disappear entirely. Complaint rates decreased. The Civilian Review Board reviewed 37 complaints in its first year and sustained findings of misconduct in 11 cases, a much higher rate than had been sustained under the old internal affairs process alone. 3 years after the Sterling Stop, the Pasadena Police Department published a comprehensive report on its reform efforts. The report acknowledged that the department had failed to identify and address discriminatory policing patterns. It credited my case with forcing the department to confront these issues and implement meaningful change. The report noted that none of these reforms would have happened without Dr. Marcus Sterling knowing his rights and being willing to fight for them. So what can we learn from my experience? What should people take away from this story? First, know your Fourth Amendment rights during traffic stops. Police officers must have reasonable suspicion or probable cause to pull you over. They must be able to articulate specific facts, not just vague feelings or hunches. You have the right to ask why you're being stopped. You have the right to know the legal basis for any search or seizure. Learn these rights before you need them. Second, remain calm and professional no matter how you're being treated. I never lost my composure. I never raised my voice or used profanity. I asked clear, direct questions and made factual statements. This made my case much stronger and gave the officer no excuse to escalate further. Third, document everything when possible. My audio recording was crucial evidence. Without it, the case would have been much harder to prove. Most states allow you to record your interactions with police officers. Know your state's laws and use your phone to document stops when you can do so safely. Fourth, understand that asserting your rights may feel uncomfortable or risky, but it's important. I knew that questioning the officer might make him angry. I knew it might escalate the situation, but I also knew that staying silent would allow the violation to continue. I made a calculated decision to assert my rights, and I was prepared for the consequences. Fifth, follow through. With formal complaints, even when the process seems slow and bureaucratic. I filed complaints through official channels. I provided detailed documentation. I followed up and stayed engaged with the process. Too many complaints get filed and then abandoned. Follow through matters. Sixth, consider getting legal help and connecting with civil rights organizations. I had the knowledge to handle much of this myself, but I still worked with lawyers and advocacy groups. These organizations have resources, expertise, and institutional knowledge that can make your case stronger. Don't try to fight the system alone if you don't have to. Seventh, push for systemic change, not just individual accountability. My lawsuit didn't just seek damages, it demanded reforms that would protect future drivers. I wanted to make sure what happened to me wouldn't happen to others. That's how individual cases become systemic progress. The 14-minute traffic stop on that quiet Pasadena street changed multiple lives. It ended Derek Cole's law enforcement career. It cost the city of Pasadena hundreds of thousands of dollars. It forced the police department to confront its failures and implement meaningful reforms. And it provided a teaching tool that has educated thousands of law students, lawyers, and citizens about their constitutional rights. But perhaps most importantly, it showed that knowledge is power. I wasn't able to prevent the unlawful stop from happening, but I was able to recognize it for what it was, document it thoroughly, and use the legal system to hold the officer and department accountable. Every time that audio recording gets played in a law school classroom, every time a police department uses it in training to show what not to do, every time someone watches or listens to it and learns about their Fourth Amendment rights, my experience continues to matter. The traffic stop was 14 minutes. The lawsuit took 10 months. The reforms took 3 years. But the impact will last decades. That's what happens when someone who knows the law meets someone who's violating it and refuses to let it slide. This is the story of how a constitutional law professor destroyed a cop's career in 14 minutes by simply knowing the law better than the officer trying to intimidate him. But it's also a story about courage, preparation, and using knowledge to fight injustice. It's about recognizing that rights only matter if people are willing to assert them. Document violations and hold people in power accountable. This narrative is a retelling based on real-life events, though the names, locations, and specific character details, such as Dr. Sterling and Officer Cole, have been changed for privacy and illustrative purposes. The legal principles discussed regarding the Fourth Amendment and traffic stops are accurate, but laws can vary by jurisdiction. This story is shared to educate the public on their civil liberties and the importance of accountability in law enforcement. It is not intended to disparage any specific individual, but to highlight the power of knowledge and due process. If this story taught you something about your rights or inspired you to stand up against injustice, please share it with others who need to see it. Hit that subscribe button for more stories about people who refuse to back down when their rights were violated. Drop a comment below and tell us, did you know you had the right to ask why you're being pulled over? What would you do in my situation? Your engagement helps these important stories reach more people. Thank you for watching until the very end.